Exparte divorce granted in favor of the husband when no summons were served upon wife. Is it maintainable? This question was decided in one judgment. The judgment is that Srimati SAROJ Singh CHAUHAN versus ARVIND Kumar CHAUHAN, dated 1st October 2019. Proceedings of the suit. After institution of suit, summons were issued to appellant. Summons were refused to be received by appellant herein. Same were thereafter sent by registered post. Ultimately, service upon appellant was affected by way of substituted service by getting publication made in a daily newspaper, Janvarta, in its edition dated 17th January 2008. Despite of aforesaid, appellant did not appear in the suit. Court below proceeded to decide suit filed by plaintiff Exparte as in the opinion of trial court. In spite of service of notice, appellant failed to appear in suit. Important paragraphs. Paragraph 17. Before proceeding to consider correctness of submissions advanced by learned counsel for appellant, it will be appropriate to reproduce Order 5 Rules 12, 17, 18 and 20 of CPC for ready reference. Rule 12. Service to be on defendant on person when practicable or on his agent. Whenever it is practicable, service shall be made on the defendant in person unless he has an agent empowered to accept service, in which case service on such agent shall be sufficient. Rule 17. Procedure when defendant refuses to accept service or cannot be found, where the defendant or his agent or such other person as aforesaid refuses to sign the acknowledgement, or where the serving officer, after using all due and reasonable diligence, cannot find the defendant who is absent from his residence at the time when service is sought to be effected on him at his residence, and there is no likelihood of his being found at the residence within a reasonable time, and there is no agent empowered to accept service of the summons on his behalf, nor any other person on whom service can be made, the serving officer shall affix a copy of the summons on the outer door or some other conspicuous spot of the house in which the defendant ordinarily resides or carries on business or personally works for gain, and shall then return the original to the court from which it was issued, with a report endorsed thereon or annexed thereto, stating that he has so affixed the copy, the circumstances under which he did so, and the name and address of the person, if any, by whom the house was identified and in whose presence the copy was affixed. Rule 18. Endorsement of time and manner of service. The serving officer shall, in all cases in which the summons has been served under Rule 16, endorse or annex or cause to be endorsed or annexed on or to the original summons a written stating the time when and the manner in which the summons was served, and the name and address of the person, if any, identifying the person served and witnessing the delivery or tender of the summons. Rule 20. Substituted services. Clause 1. Where the court is satisfied that there is reason to believe that the defendant is keeping out of the way for the purpose of avoiding service, or that for any other reason the summons cannot be served in the ordinary way, the court shall order the summons to be served by affixing a copy thereof in some conspicuous place in the courthouse, and also upon some conspicuous spot of the house, if any, in which the defendant is known to have last resided or carried on business or personally worked for gain, or in such other manner as the court thinks fit. 1a. Where the court, acting under sub-rule 1, orders service by an advertisement in a newspaper, the newspaper shall be a daily newspaper, circulating in the locality in which the defendant is last known to have actually and voluntarily resided, carried on business or personally worked for gain. Class 2. Effect of substituted service. Service substituted by order of the court shall be as effectual as if it had been made on the defendant personally. Clause 3. Where service substituted, time for appearance to be fixed. Where service is substituted by order of the court shall fix such time for the appearance of the defendant as the case may require. Paragraph 19. When procedure adopted by court below for service upon defendant appellant is examined in the light of provisions contained in Order 5 Rules 12, 17, 18 and 20 of CPC, this court finds that there is no compliance of Order 5 Rule 17 CPC. Secondly, there is no endorsement by process server in terms of Order 5 Rule 18 CPC, nor court below has examined process server under Order 5 Rule 19 CPC. Service of summons by registered post, which is contemplated under Order 5 Rule 19A, came to be omitted by Act 46 of 1999. Therefore, no service by registered post could be made. Lastly, court below has not complied with the mandate of Order 5 Rule 20 CPC before directing service upon defendant appellant by way of substituted service. Paragraph 21. In view of discussion made above, we have no hesitation to allow these appeals. Accordingly, both appeals are allowed. Judgment dated 25th July 2017 and formal order dated 23rd August 2017 rejecting recall application filed by defendant appellant under Order 9 Rule 13 CPC and as well as judgment and decree dated 8th May 2008 and 4th August 2008 decreeing suit of plaintiff respondent ex parte or set aside. Marriage petition number 565 of 2007 ARVIND Kumar CHAUHAN versus SAROJ SINGH CHAUHAN is restored. Defendant appellant shall be permitted to file her written statement and thereafter court below shall proceed to decide the marriage petition on merits afresh. Appeal allowed.